on the part of the judges. Because on the part of the president, it's Article 133. Is there any law which is guiding the decongestion, which is usually undertaken by the High Court judges?
Thank you. Thank you, Judge, for that question. I do understand under the mercy and the advisory of the committee, the president decongests by offering the presidential pardon and also through commuting sentences, maybe converting from death sentence to life imprisonment. Under the High Court, I will say it will be the sentencing guidelines that will guide judges.
Sentencing guidelines?
Sentencing guidelines in the criminal.
I believe the sentencing guidelines are guidelines prior to sentencing. They guide the court on how to make a sentence. These are people who have already been sentenced. They are serving a sentence in prison. But you will find your way there, and you'll be called upon once in a while to decongest, so to say. Do you think there's any law? Or maybe you may look at it. It's important because you may have to exercise that jurisdiction somewhere.
Judge, I would like you to clarify.
Yeah.
Are we looking at going back to the prisons, the cases that have already been decided and people have already been sentenced?
Yes.
Or are we going to people who are yet to be sentenced?
No, after sentencing.
After
These
sentencing?
are serving sentence.
A serving sentence.
Yes.
They can make an application to the court?
Now, the scenario which I've given is what is happening at the moment. If an application is made, you consider the application, and of course the application must be having some provisions in which it's brought under. But this is a case whereby you visit, as a judge, you're supposed to visit the prisons and to undertake an exercise tantamount to decongestion. So I'm just trying to find out whether maybe you may be aware, maybe under what law we exercise that jurisdiction.
I will make use of the Court Uses Committee by engaging all stakeholders in the criminal justice system.
Okay.
Under Section 35 of the Judicial Service Act, and see if there are those ones who are reformed and the sentences need to be changed. But I stand guided, Judge.
Okay. Thank you. I wish you the best.
Good morning again. Have you dealt with any cases with regard to matrimonial property?
Yes.
Now, Article 45(3) of the Kenyan Constitution guarantees that parties to a marriage are entitled to equal rights at the time of marriage, during the marriage, and upon its dissolution. This constitutional provision is reinforced by the Matrimonial Property Act of 2013, which establishes that both spouses have equal rights to matrimonial property. Now, as a judge, how would you distribute the property of a polygamous man who died intestate, where the first wife claims that some of the property subject of dispute were acquired before the deceased marriage to the second and third wife?
Thank you, AG, for that question. So it is true under Article 45(3), it calls for equality of the spouses, both at the beginning, during, and dissolution of the marriages. So it's a polygamous man, right? The question talks about a polygamous man. So I will invoke Section 40 of the Law of Succession, where the estate is divided among the houses according to the number of children in each house, with each wife counted as a unit. That will be my first part of the question. And if it's a polygamous marriage, it will look at the wife who was living in that. I will define what a matrimonial home is. And if that counts as part of the matrimonial home.
My question was, this man is married to one wife. They hold property. After some time, he marries the second, then the third. He dies intestate. How would you distribute the property that the first wife is alleging was acquired when there were two, before the second and the third wife came to the scene?
Her share will just be limited upon proof that that property was the one she acquired with the spouse when he was living.
How would you distribute?
I will distribute equitably based on their contribution, both monetary and non-monetary, and it's not an arithmetic test as was established in the case of Rono against Rono. So it will only be pertaining to her interest regarding the properties she acquired with that man during his lifetime before the other spouses came on board.
What about the property that each wife came with?
The property that each wife came with,
yes,
you'll have to establish what interest or what contribution she did to those properties. If she cannot prove she contributed to it, whether monetary or non-monetary, then she will not be entitled.
If you are married as a second wife and you come with a house, how would it be treated?
That property will be treated as your own. If they cannot prove that they contributed to it, whether monetary or non-monetary. You came with a house, right? But did they do any other thing to its contribution? Maybe they did non-monetary, maybe renovations, they added something to it. If they cannot prove it, then the house will just belong to you.
Thank you, Honorable Chief Justice. One or two questions from me, Wakili. Now, in the area of division of matrimonial property, you have a husband and wife, and they have shares in a company. Say the husband has 70%, the wife has 30%. Their marriage has hit headwinds. How would this property be divided between the two of them, the husband and wife, and the only property they have is that limited liability company with that shareholding of 70 and 30?
Thank you, Judge, for that question. So their marriage has come to an end, and under Article 45.3, the equality provision still prevails at the beginning and during and the dissolution of the marriage. Despite having 70 and 30, the wife has to state what contribution she did so that she'll be entitled to more. It's not an arithmetic formula of 50-50, it's an equitable distribution. So she will need to prove what other things she did non-monetary for her to be entitled to more in the division of that asset.
Supposing she never made any contribution at all?
Then she'll just be entitled to what she had initially.
All right. Fair enough. Now, let's again assume we have a situation of a husband and wife, and they are both Muslims. They have been married. Again, their marriage has hit headwinds. And in the course of that marriage, the wife converted to Christianity. And now this marriage needs to be dissolved. Where do they go for the dissolution of the marriage? One has become a Christian, the other one is still a Muslim. They contracted an Islamic marriage.
Thank you, Madam Judge, for that. Actually, unless the man does not want to be married to her anymore, under Islamic law, nothing stops him to continue living with her, despite converting to Christianity. Despite that, they can just go to the High Court for the dissolution of the marriage, because under the Qadi Courts, Section 175, the jurisdiction is to those who profess the Islamic faith. So she can opt out and submit to the jurisdiction of the High Court for the dissolution of their marriage.
Supposing the position was to be reversed, it is the man who has converted to Christianity.
If the man converts to Christianity
and the wife is still a Muslim,
under Islamic law, then that marriage is automatically dissolved. So she can go to the Qadi courts asking for dissolution of that marriage on grounds that he has left or deserted the religion.
All right. Thank you. That's all from me, CJ.
Thank you. Wakili, I don't know whether you've read the decision of Methodist Church versus Fugicha from the Supreme Court that also handled an issue about faith, about Islamic faith. Perhaps if you can tell us what was the decision in that case by the Supreme Court, and then secondly, depending on how that decision was made, if the decision now started from the High Court, how would you apply it as a judge, and would your faith affect your faith that you profess affect how you judge this matter?
Thank you, Commissioner, for that question. The case of Muhammad against Fugicha, the case of the Methodist Church of Kenya against Fugicha is one that went all the way to the Supreme Court, but the Supreme Court did not pronounce itself on what their findings, the ultimate findings were, because of the manner in which the parties came before the court. It was the interested party who introduced a cross petition, but nonetheless, I will have associated myself with the dissenting judgment of Justice J.B. Ojwang. It was the issue, the contest on was between the Methodist Church was the sponsor of a school based in Isiolo, and the students had signed an agreement, a consent, that they will be binded by the school uniform. Now, 3 students, who are the children of Mr. Fugicha, went on ahead and started wearing the hijab, contrary to the school uniform. So this matter went to court, and it went all the way to the Supreme Court. In the dissent of J.B. Ojwang, he says that the wearing of the headscarf did not favor the Muslim girls the same way it did not discriminate against those who were not Muslims. So I will invoke Article 32 of the Constitution to do with the freedom of religion. The wearing of the hijab is a practice and observance of one's faith. The school, as much as being a Christian-based school, is still guided by the Education Act. I believe Section 27 says that they have to respect different religions and denominations. My faith will not affect if it comes to matters to do with the justice. I will always look at Article 27 to do with equality. Of course, as a judge of the High Court, I will always be binded by the Constitution, which remains the supreme law of the land. And I think for purposes of encompassing diversity and embracing the values in Article 10, which includes equality, inclusion, embracing people from different groups, I will tell the school maybe to sit down, have a stakeholder meeting with the students and people, and come up with an acceptable hijab that will be in tandem with the uniform of the school.
So would it be the choice of the families and the girls about the school uniform, or still the school has a say about the type of hijab, the color, and those sort of things? Because the school still has an interest in teaching and enforcing discipline. So as a judge, how do you balance between those? How do you balance between the right to practice one's faith and the interest, the communal interest of the school and the entire school community to have order and discipline and those sort of things?
I will say the two issues are mutually inclusive of each other. They're interdependent. As much as the school has got the authority to lay down the uniform, the preferred edit will be they come up with a way where they embrace also people from different faith, allowing people to practice their religion under Article 32, and also encouraging diversity, because at the end of the day, I believe they're preparing the students for a diverse world where they will encounter people from all walks of faith. So I think it's important for the harmony and for the education for the children that the school also operates within the confines of the Constitution in upholding people's religious beliefs.
All right. Thank you, CJ.
Thank you, CJ. Good morning once again.
Good morning.
I am looking at your CV and also your profile. You have essentially been practicing law since after your admission, right? That's basically what you've been doing.
Yes, Commissioner.
Which is the highest court you've practiced in?
That will be the Court of Appeal, Your Honor.
Okay. So under the Constitution, as we select members or candidates to serve in the High Court, there are 3 categories, and I believe you would fall in the category of distinguished legal practitioner. So please demonstrate your distinction. Tell us what distinguishes you.
Thank you, Commissioner, for that. I believe what distinguishes me is that I've been a career practitioner of the law, that I'm good in drafting, not only legal documents, but also many other legal publishing journals that I have drafted, and especially in my university days. I have a good interpersonal skills, especially when it comes to team building. I'm a team player, and also integrity. My integrity speaks for itself, and those are the things I want to bring to the judiciary.
Okay, you practice in Nairobi?
Yes, Your Honor.
How big is your practice?
Our practice is based in Nairobi. We have 15 advocates and 3 partners, 18 in total.
Okay. Do you participate in CUC or bar bench committee meetings in Nairobi?
Yes, Your Honor.
Okay. When is the last meeting you attended?
The last meeting I attended was last year around, I will say March last year.
Which court specifically?
It was the Anti-Corruption Court.
Okay. What are the issues that the Anti-Corruption Court is grappling with?
The issues the Anti-Corruption Court is grappling with is to do with transparency, integrity issues, and also delivering of judgments that take long time. And also the score rate is really low, especially when it comes to prosecuting and also convictions for people, especially in high places in government.
What did you say is low? Sorry?
The conviction rates of public officers. Yeah.
Okay. So what was your contribution towards absolving, especially that particular one, the low conviction rate?
Low conviction rate? Mostly it was a two-edged sword, I will say. Mostly it was the evidence that was being brought to court was very weak. So I will have advised the concerned authorities to really make sure they bring watertight pleadings and documents to court so that the conviction rates will go higher.
This is Anti-Corruption High Court or Lower Court?
This is Anti-Corruption Lower Court.
Okay. I see here you are working at Voltic Kenya. You are a board member at Voltic Kenya.
Yes, Your Honor.
What is Voltic Kenya?
Voltic Kenya is a private company that deals with IT, using IT solutions for the transport industry.
Oh, okay.
Advise them on legal and compliance matters.
Okay. So finally from me, maybe I can ask you something concerning case management. So one of the key outcomes of STARGE is efficiency, accessibility and efficiency, but I want to focus on efficiency. Give me 2 overriding objectives of case management in criminal cases.
Thank you, Your Honor. I believe you meant the social transformation to access to justice, the blueprint by the judiciary,
yes,
and how it assists with overriding objectives in the criminal system, yeah? Introducing a multi-door system, I will say, towards dispute resolution when it comes to criminal matters.
We will get there. The first thing I wanted to ask, the overriding objectives.
The overriding objective is to dispense with the matters expeditiously.
Yes, that's one. The second one?
Proportionately and affordability.
No, I'm saying overriding objectives in criminal cases. You've mentioned one, expediency. The second
Yes.
one?
Transparency and accountability.
Just conclusion of cases. Okay? So now tell us how you will go about achieving that. Just conclusion of cases and expediency in criminal cases.
Okay, there are a number of issues I will employ in that, especially the case management meeting. I will make sure that the parties have complied with the rules that comes to pleadings, and also that they can employ, whenever necessary, alternative justice systems or ADR mechanisms.
Sorry to interrupt you. What are these pleadings you're talking about in criminal cases?
The the pleadings that the parties present to court.
In criminal cases?
In criminal case, oh sorry, I meant, I thought you asked the civil. I didn't know it's criminal.
I'm specific to criminal.
Or criminal matters, or that the parties comply with. The plea taken, perhaps like the charge document, the parties are given an opportunity to respond.
Okay. Maybe you can run us through the steps of a criminal trial.
Thank you. A criminal trial starts with the arrest and detention, and then after that,
the trial.
The trial itself. Okay. The trial is outlined actually in the Constitution. It falls under fair hearing, where parties at first are assumed innocent until proved to the contrary. So at the trial, they're presented in court, where the charges are read to them in a language they understand.
Yes, we start with the plea taking. You read the charge in a language they understand, yes.
And then after that, they're given a sufficient time to respond to the same. They can plead guilty or not guilty. If they plead guilty, then we move to conviction. If not guilty, then we proceed to the trial, where the court now will come and set out the rules for the trial as they proceed with the whole criminal procedure.
Yeah, I want you to run us through the process. So the accused has pleaded not guilty. What is the next step that you take?
They have not, they pleaded not guilty, then we move to trial. Now they will have their advocate in place, and then now the court will set a place for, they will move to trial. Now the trial process will begin. The court will set a time. So during the trial, again, the charges will be read to the person, and then after that, they have pleaded not guilty, so we proceed with the presenting of evidence, rebuttal of that evidence, until we reach conclusion. Actually, the plea-taking process was outlined in the case of Arden against Republic, where the court pronounced itself on how the whole procedure should be conducted.
So the accused has, the evidence has been presented, I presume you are by the prosecution, right?
Yes.
And then what, after the prosecution has finished, what is the next step?
The defense attorney now will come and rebut the evidence in a way that they will poke holes and try to fight for the innocence of their client, the accused.
There's a critical step you're missing. The prosecution has closed their case. What is the next step?
The prosecution has closed their case.
Yes.
So the next step now, the judge is going to give directions. We move to the accused defense attorney.
I think you may need to refresh on that. Eh? Now let's go to where the accused has pleaded guilty. What is the next step?
Okay, once the accused has pleaded to guilty, then the judge, the judicial officer will move to sentencing, taking into account any mitigating circumstances.
No, walk us through the steps. Eh? The accused has pleaded guilty. What is the next thing you do?
Okay, the accused has pleaded guilty. The next step you do is sentencing. You move into sentencing.
Okay, I think you need to refresh on that.
Okay, in the sentencing, they have guidelines on the same.
Yes, they're there. But you need to appraise yourself of the steps you take from A to Z in a criminal case.
Okay, thank you for that.
Thank you, my lady.
A quick one, CJ. Yes. Maybe just one follow-up question. What happens if the accused person keeps quiet?
If the accused person keeps quiet?
Yes.
The court will have to inquire why the person is quiet. Is this a reason because they cannot speak or because there's some other underlying issues? They will have to go for re-examination of that person.
If they still keep quiet?
If they still keep quiet, I will not know what the court will do. I'm not familiar what will happen next.
Thank you.
Unless they're being hostile to the court.
Okay, good morning once again, Naima.
Good morning.
You can have water
Thank you.
if you need, and then I can take you through the next set of questions. Okay, I've gone through your sample writing. You submitted 5 of them. 3 were submissions, 1 on ELRC constitutional petition, 1 High Court JR, and another High Court civil matter. You also submitted 2 articles, one that relates to hiccups on criminal justice in Somalia and a legal advisory on community land in Wajir. So the sample writings reflect excellent issue identification, deep engagement with facts and law. They are well structured, and you are able to navigate statutory interpretation, jurisdictional question, and constitutional principles while maintaining internal coherence and clear conclusions. Your tone is professional, and you use precedent effectively. I have noticed that in the journal articles, they are undated and nothing shows that you are the author. So maybe you can explain to us about that. And then in the civil matter, the submissions in the civil matter, it's drawn and filed by the firm of Njoroge Washira and Company Advocates. Maybe you can also tell us whether you worked in that law firm. That's the matter of, just let me read out. Just the matter, yes. It's the Nairobi City County matter. The submissions that have been filed are by the advocate's plaintiff, and it's the firm of Njoroge Washira. So maybe you can explain to us the 2 issues before I take you through the next questions.
Thank you, Commissioner, for that. Actually, for the Wajir matter, it was supposed to be dated in July 2022, and for the Somalia matter was something I did for May 2024. I'm sorry, it was an inadvertent mistake on my part. It had a cover page. It was a report, so I think when we removed the report and were feeding into the system, I think some of it was left out on the report, and it has the signature of the signing. So I apologize on that, and with permission, I can produce that to the Commission. Okay. As with regard to the Njoroge Washira and Company Advocates, it's true, I briefly worked there before joining the firm of Rectangular Urban. I had a stint of about 2 months.
Okay, I just needed to clarify that because it doesn't appear on the CV. Thanks for the clarification. So in one of your submissions, the KEMSA matter, which was a constitutional petition, you argued that the court lacked jurisdiction to entertain the JR application because the same was time-barred by virtue of the Law Reform Act and the Civil Procedure Act. Is that the position in law?
Thank you, Commissioner, for that. That was
a
one
constitutional petition, yes.
Yes, for the constitutional matter for KEMSA. The reason why I included that for the time bar was because they were asking for a certiorari order, and under the law, it ought to be asked within 6 months. So they were coming to court almost 2 years later asking for certiorari orders that ought to have been asked within the 6 months period, and they never gave any explanation of the delay.
It was a constitutional matter. Constitutional matter. What is the position?
The constitutional, they were framing it. They were framing it as a constitutional matter, but it was the primary subject was an employment matter with constitutional peripheral matters, but the core issue was an employment matter.
Can you claim constitutional violations or constitutional issues in an employment matter?
Yes, you can, Commissioner. And that was decided in the case of Edwin Dande against IG.
Okay. Lastly, Article 2.5 of the Constitution provides that general rules of international law shall form part of the laws of Kenya. How has the Supreme Court interpreted the application of these general rules?
Thank you, Commissioner, for that. Yes, the international laws come from part of the laws of Kenya through ratification, but they play a persuasive role Kenya still remains a dualist state, so they do play a persuasive role. I believe the court applied that in the case of Me Too Bell against KAA. When it came to socio-economic rights, they focused on the UN guidelines on eviction.
Thank you, Chair.
Good morning once again. I want to talk to you a little bit more about your writings. My first question, you did a master's in oil and gas, but you haven't given us any writings on that. I was curious. During your master's program, did you have a thesis of any kind? And if you did, what was it on?
Thank you, Lady Justice, for that. Yes, I did my thesis on land, on the human rights issues that will arise in oil exploration in Turkana. That was the time when we thought like Kenya will become an oil producing and exporting country. Sadly, that dream did not take off. So my writings became limited once Kenya stopped exploring oil and gas.
Oh, thank you. Then let's move to your legal advisory, in which you talked about some ADR and AGS in Wajir. You also talked about the use of maslaha. Could you please tell us whether there are any constitutional limits on the use of maslaha, and if you can give some examples?
Thank you, Commissioner, for that. The use of maslaha system is very important in societies like Wajir, where I wrote about, where they always pursue alternative justice system because they focus more on restorative justice rather than retributive, and they want to maintain the relationship among others in the community. But it does have its shortcomings. I do not advocate for the application of maslaha in murder cases. I do understand there have been rare occasions where it's been applied, like in the case of Muhammad Ado. But then, in my opinion, there's certain safeguards that do not come with the maslaha system, such as sexual offenses cases. I believe should strictly not be formed part of maslaha when it comes to rape and defilement, because mostly you cannot get justice through the maslaha system.
Okay, thank you. No other question.
Just a quick one here. I did not understand your answer to Lady Justice's question on your thesis. Did you write a thesis in your master's when you with regard to the subjects that you mastered in?
Yes, I did.
What happened to the thesis?
I did not include it as part of my documents. I did not submit it, but I did write on community land grant ownerships vis-a-vis the oil exploration.
Oh, so you wrote it and finished it?
Yes, I did, Your Honor.
Thank you, Honorable Chair, and welcome again, Wakili Naima.
Thank you.
What is your stance on the separation of powers, and how would you navigate potential conflict of power struggles between the judiciary, the executive, and the legislature?
Thank you, Commissioner, for that question. The judiciary forms one of the arms of the government. It's an independent arm of the government, but quite inadvertently, some matters come before the judiciary that concerns other arms of the government. That's when judicial officers need to exercise judicial restraint, and they do not descend into what is known as the political question doctrine. Certain issues are politically inherent and best to be served by other arms of the government, as was established in the case of Luther against Bourdain. So in respecting other arms of the government, there's certain issues like the court should stay away from to safeguard institutional integrity, and so that judges and judicial officers are not accused of overreach, like the integrity test of the current president and the former president, where there was a petition filed against them that they should not contest in the 2013 case, and the court threw right back and said that's a question best decided by the electorate. So the judiciary has to have a balancing act and respect the other institutions and only focus on things that strictly fall within the realm of the judiciary.
Parliament. How does the judiciary relate with Parliament?
The judiciary and Parliament are interdependent. Laws are made in Parliament, and the judiciary often interprets that law through constitutional petitions. But where the laws are invalid because they do not align with the Constitution, that's when the judiciary will come in to stop a violation of rights under the Bill of Rights.
Thank you, Honorable Chair. Wakili, I have just 2 questions for you. Please demonstrate to us circumstances when you would use these approaches in decision making. 1, the command decision making. 2, consulting decision making. And 3, consensus decision making. And maybe while at it, you could give us merits and a merit and demerit for each.
Thank you, Commissioner, for that question. I believe those are 3 leadership styles. Command you need when you need to be decisive and make decisions quickly, because if you start consulting with everybody, you might not move forward and you already have your vision. So the good thing with the command system is that you will move efficiently and effectively, but the demerit about it is that you might be seen as being dictatorial and not taking into account other people's views. Consulting is when you need to explore. Maybe you are limited in that area, so you will benefit from others coming together and giving you ideas. It's good in the sense that you will reach a holistic approach to resolving issues, but the demerit is that it will take long as you look for consensus, and different people will come with different opinions on the same issue. Consensus, you need it when it's something that you need for the whole organization to feel like they're part of the dream, like in delivering the mission or vision, like for the judiciary. So you will need people to feel part of the system. And the demerit is that it will also be time consuming because you will need to collect views from everyone, and it might also be resource constraint as you engage in collecting data for the same.
Okay. How important is organizational culture to you, and what measures would you make to maintain your desired culture?
Organizational culture is very important. It gives the way forward for any organization to build on it. What's the culture of the judiciary, for instance, is to safeguard justice, to integrity. So once the people know of the organization, the culture, it makes you able to reach your vision faster. So I think just to maintain is that the people around you need to know what the organizational culture is so that they can behave accordingly.
Okay. Thank you, and I wish you well.
Thank you.
Yes, now, can you tell us about your activities that you do with the community? Do you do any social responsibility work?
Thank you, Commissioner, for that. Yes, I do a number of social activities. I mentor young girls from marginalized communities. I mentor them in the law and in their career decisions. I'm also the Secretary General of a relief organization. So I play a part in the community, and that's what I do amongst the community, and also involve myself in charitable organizations.
Charitable?
Organizations.
Organizations.
Yes.
If you are to be successful as a judge, how do you manage those charitable works that you do?
Thank you, Commissioner, for that. I think the work of a judge is very engaging, so I will need to relinquish my position in those organizations and let others run with it, because one of the conditions of being a judge is that we live a very reserved life. So you try as much as you can not to be seeing things that might be construed or might be inferred otherwise.
Do judges participate in public collections?
Commissioner, if you mean public collection of money, for instance?
Rambes?
Harambes, I will say it will not be advisable for the stature of a judge. You can delegate to others, because somebody can infer and conclude wrongly your intention for collection of the Harambe.
Is there a situation where that can be waived and the judges can participate?
Maybe if it's driven by the judiciary, and maybe if it's been something that you have been given the green light by the Honorable CJ, I think then you can go ahead within certain guidelines.
Okay, thank you.
Thank you very much. Finally, what is your world view? How do you view the world, especially in relation to the threat of terrorism?
Thank you, Madam CJ, for that question. I view the world through the lens of positives. I always look the best through the world. Yes, there are terrorists there, out there. There are bad guys there. But my philosophy in life is that always the good guys always win the race. And I do not let fear control my life or to be threatened. But it's good to be alive to the threats and also to come up with measures to combat the same. And history has shown again and again, the good guys always win. Mm-hmm. So I look through the world through a positive lens.
Very well. I think this brings us to the end of this very interactive session. Our apologies for the interruption by the alarm which went on. But before we release you, we always give a candidate an opportunity also to engage us. The floor is yours.
Thank you, Madam Commissioner, for that engaging 1 hour round of intense questions. For me, I just want to say thank you for affording me this affording me this opportunity. With me, I carry the dreams and aspirations of thousands of girls from marginalized community. I dare say this is the first time a lady judge from Northeastern Mandera has been shortlisted. That in itself is an achievement for me to be in this room with such phenomenal ladies, no more or less. I hope one day to follow in your footsteps, Honorable CJ, and I can see very other wonderful ladies. The Honorable Fatuma Sichale being the first Muslim CJ in the first Court of Appeal judge. I can see the Lady Justice Njoki, who was the youngest, and came up with such a remarkable act, the Sexual Offences Act, which has really helped people from my community. So mine is to say thank you for giving me this opportunity.
Well done. We will get in touch with you when we complete the process. But meanwhile, on behalf of the commissioners, we wish you all the best and encourage you to keep up doing the good work that you're doing for the community and mentorship of the young girls and in the legal profession.
Thank you, Honorable CJ.
Have a nice afternoon.
Thank you, Commissioners.
Yeah.
Thank you.